This panel is about the New York tax laws and how it's affecting affiliate marketing and basically this possible solution that you could all start to use. So the New York tax law is basically if you have an affiliate or a set of affiliates, and it's very vague, so there's no actual interpretation that lawyers can agree on for the definition. And basically, if you have $10,000 in sales from a New York affiliate going to a resident of New York, you are now required to collect taxes on the goods shipped in. And basically with the panel, what we're going to do is we're going to first present who we are and how the law has affected us from the different issues. And then we're going to go into, Clarke is going to present what nexus is and go into more detail about the law. Then Chris is going to present some of what Google Performix has recommended to merchants. And then Melanie Siri is going to present the solution that was created by a New York tax attorney. Now, Clarke is an internet lawyer, so he's the only one that could actually give legal advice on this panel. The rest of us can provide you with input. And the other issue is, since it's a law and it's very vague, it's constantly changing. So what could be a solution today may not be a solution tomorrow or next week. And this is why it's a big issue, especially if other states decide to move forward. So I guess I'll start. My name's Adam Riemer, and I'm an outsourced program manager. And when the law came to pass, or when the law started to come out, we had to talk to all of our clients and tell them what they're going to be required to do. We had to give them the option to remove New York affiliates. Luckily, none of them did. And we had to try to come up with solutions and a reasonable course of action for them. And that way we wouldn't have to remove New York affiliates. And luckily, most of them have nexus in the state of New York, and none of them ended up removing them. Next, we have Clarke Walton from Walton Weblaw.
Good afternoon, everyone. Thanks for being here. My name is Clarke Walton. I'm an internet law attorney from Las Vegas, Nevada. The affiliate industry is an industry that's very near and dear to my heart. I actually paid for law school as an affiliate, selling video game accessories over the internet. And today, in my law practice, I represent exclusively website businesses. A large portion of them are either merchants or they are affiliate networks. And so quite a few of my clients have called me asking for information about this topic, and I'll share with you today what I've shared with them.
And next we have Melanie Siri, who is the New York affiliate voice, nyaffiliatevoice.com, I believe, and she's a New York affiliate.
That's right. Good afternoon. I'm Melanie Siri, and New York Affiliate Voice is my blog, and it's a personal blog. It's not associated with any group or organization. It was my way of just voicing my opinion on affiliate issues and things that are affecting me. What happened beginning in May was I started to see that my business that I spent years and years developing, I put my heart and my soul in the business, it was being torn apart. And how it was torn apart was by merchants saying, we can't do business with you. Terminations were pouring into our mailboxes, and we would swap out links from one merchant to a next, and then the very next day, that merchant would send a termination letter to us as well. So if you can imagine having a store, owning a store, and going into your store on a Monday morning and there's nothing on your shelves, how do you continue to do business? I've lost anywhere from, talking to various New York affiliates, we've lost anywhere from 20 to 90% of our income as a result of this law, and that's 2 months old. New York affiliates, we started asking questions because we needed answers. We needed to know where it was going, where merchants were going, and what we could do. And the bottom line is nobody knew anything or nobody was telling us anything. So one of the other things that was probably the hardest things for us to deal with is that merchants were notifying us, and they were saying, sorry for the temporary inconvenience, but we're terminating you because of the New York state law. And they left us. Now, it wasn't a temporary inconvenience because this is our livelihood, this is how we support our families. My business, I spent years and years developing this, and it's not my personality to sit back and just watch it all tumble down and say, okay, I'm gonna wait until, Amazon settles their lawsuit, because that lawsuit's gonna go on for 5, 6, 7 years. To try to wait for New York to repeal the law, that also is something that's gonna be a long-term process. I needed a solution for now. Kevin Webster and I began to talk about having a meeting, and all of a sudden, we were overwhelmed by the support, and it took us by surprise because we didn't know that the support was out there. We had people from all facets of the industry. We had other affiliates. We had New York affiliates, and we had affiliates from California, Texas, Canada, from overseas. We had merchants reaching out to us, and we had networks reaching out. And what they did was they decided they were going to sponsor our meeting so that our meeting could be what we needed to have. We met in Albany on July 28th, and it was about 7 or 8 affiliates and about 4 program managers, and including Kim, who showed incredible guts to show up in a room filled with affiliates that she had kicked out of her program. And what we did, we sat down, terminated, yes. We sat down and we did something that had been missing and something that was needed in the industry. And as we sat down as business partners and we spoke to one another and we understood where everybody was coming from. Once we understood the solution, and we did it all with respect. We didn't do it with animosity. We were joking, having coffee, and everything else. We did it as business partners, and we had to treat it as a business problem. And we came to a solution. We knew what we needed to do. We brought in our attorney, Mark Klein of Hodgins Ross Attorneys. It's a leading New York State tax attorney. And he said, this is the law. This is what you have to do. If you have any questions? We asked him a ton of questions. The 2 hours with him flew by. He walked out the door. We're all ecstatic because we have a solution. Now, what we had to do from then is we have to say, okay, what are we going to do about this? We have a solution. We have to do something. The very next day, we retained his services again and said, please, help us draft the documentation that we need so that we can communicate this solution, because it's a simple 2-step process that merchants have to go to avoid having a nexus in New York State and still partner with New York affiliates. We valued our relationship with merchants to such a degree that affiliates, we sacrificed our time and energy over the last 3 months. My life has been consumed with this issue, as you may judge by my blog. But what we did was we're working really hard. So right now we have the solution. It's on this paper, nice, simple, clear-cut instructions for you as a merchant. We have the version that your lawyers might need. We have to implement this. And one thing that you have to realize is we have the solution. We're presenting you the solution that we can survive today. And the next step now is up to everybody else. And your reaction to this solution is going to say a lot about our industry as a whole and how affiliates are valued. You need to value your affiliates. Affiliates need to value the merchants and the networks, and we need to have mutual respect on it. We're hardworking people. And we need you to move on this and implement this solution. And if you don't, then you know what? You're losing thousands and thousands and thousands of affiliates.
Thank you, Melanie. Next we have Kim Rogers, who's from 4 Checks.
Good afternoon. I sit before you today a terrified person, not a speaker by any means, and up until 2 weeks ago I was going to sit before you and tell you that I do not have New York affiliates in my program that I can successfully work with. However, today I can tell you that we were able to comply with the New York State tax law and that we are able to work with them again. And it's because of people like Melly and Kevin and Rhea and Patrick and everyone who put forth any type of an effort to get this taken care of. Heiko, who gave us a forum and a place to talk. It was not my plan to ever discontinue these relationships, terminate, or kick out anyone. It's not my job. This isn't a job to me. It's always been something that I've loved and have been blessed to see grow beyond what I ever expected it to be. And I didn't even hear about the law through the normal channels. I heard it from ABES Web. And I said, oh, that's not going to affect us. I'm not going to worry about it, but I'm sending the link to my CFO. So I did. And he said, you're fine. We're fine. It's not a big deal. It's never going to pass. And then we creeped very, very closely to the deadline. And I said, we're still okay, right? And he said, we're fine. Legal? Said, we're fine, we're fine. 2 days before the deadline, they shared with me that the law itself was just too ambiguous in nature for us to allow the relationships to continue. So I had to go to A-Best Web, where I had posted originally that we could work with New York affiliates and give the horribly devastating news that we could no longer do that. And I felt horrible about it. It was definitely one of the lowest points of my life, my career, because I had told people that I really care about that they were safe with me, and in the end they weren't. And I didn't give them any notice. It was the 7th inning of the game when they found out, and they found out when I found out. And since then we've been working together for a solution because there's just nowhere else to go but up at this point. It's unlikely, as Melly said, that it will be repealed quickly. We can't wait to see what Amazon does, and to make sure that we're in compliance, which I've been lucky enough to find myself able to do. So it's not a difficult thing. Any merchant can do it if we can do it, and I want to help other people be able to work with New York affiliates again. So if anybody has any questions, I'm more than happy to share whatever I have with you, whatever I know, and we really need to get this squared away.
Thank you, Kim. And as Kim mentioned, abestweb.com is a fantastic resource with a lot of very good discussions about this topic. So I encourage you all to check the forums out and join as a member. It's a very good resource and a very strong resource. Next we have Chris Henger from the Google Affiliate Network, Performix.
Thanks, Adam. Hi, I'm Chris Henger from the Google Affiliate Network, which was formerly Performix, and now we've rebranded. So this conference will be a litmus test on how well the name is sunk in, so we'll see. This issue was an interesting one for the role of the network. We monitored the situation throughout. When it first originated in November, I don't know if people realize that it hit early in November and then they immediately repealed. Within 24 hours, Spitzer went forth and said he's not going to bring it to the floor to be a bill. But then it resurfaced again in the spring, which everybody's aware of. We viewed our role as trying to facilitate communication to both advertisers and publishers. It was kind of tough. I mean, we certainly worked with our own internal counsel, and as Kim alluded to, the law is somewhat ambiguous, and we weren't in a position as a network, nor was it really our job to come out and to tell a merchant what to do. It is a merchant issue in the sense of is Nexus being created for the merchant, and it is up to the merchant to collect the tax. So when we spoke to clients, it was under the guise of you really should seek outside counsel or up through your finance or legal departments. We have a platform where advertisers can identify New York-based affiliates, so you can run a simple report and see if they're from New York. And throughout this process, we've had a lot of advertisers who've taken the route of termination, and that was the initial reaction when it really hit at the end of May. And since then, we've had several advertisers who've taken a route that I think both Kim and Melanie will talk further on, which is the steps needed to comply as interpreted today. So that's kind of the background so far.
Thank you, Chris. Now Clarke is going to talk about what Nexus is and a bit more in detail about the law.
I'm going to stand up so everyone can see me, of course. Can everybody hear me okay? So the New York affiliate tax law, at first glance, you would all think that the New York affiliate tax law is exactly what it sounds like, which is a tax law. But really, the questions that are at issue with respect to this law are not tax questions. They're constitutional law questions. And so what I want to do is provide all of you with an understanding of sort of the underpinnings of the law and the constitutional issues that are really at the heart of this thing. And in order to do that, we're going to start with a couple of definitions. And one of them is going to be something called the Commerce Clause. How many people in here are familiar with something called the Commerce Clause? Has anyone heard that? Okay. So Article 1, Section 8 Clause 3 of the U.S. Constitution. Basically, it says the following. It says that Congress shall have the power to regulate commerce among the several states. And what that means, in short, is that when transactions are taking place between different states, that's under the purview of the U.S. Congress. And so it's not a state issue when transactions are taking place among different states. We have a parallel to the Commerce Clause, and it's called the Dormant Commerce Clause, or also called the Negative Commerce Clause. And this isn't explicitly stated in the Constitution, but it's really at the heart of our problem today. And the Negative Commerce Clause has been created by courts over a couple of hundred years. And essentially what the Negative Commerce Clause says is this. If interstate commerce among the states, is under the power of Congress, under federal Congress, then states shouldn't have the ability to pass laws that have a negative bearing on that, right? Or could unduly burden commerce among states. So we know that states have the authority to tax the citizens of the residents of their own states, but to what extent should they have the ability to tax out-of-state companies, right? When they tax out-of-state companies, what do we do to make sure that taxation is fair, and so that it doesn't burden or violate this Negative Commerce Clause? And in order to make sure that a state taxing out-of-state companies is fair, we have a test, and the test is that there must be a substantial nexus between the out-of-state business and the company that wants to tax the out-of-state business. And so then we try to decide, okay, well, that's useful, but what's a substantial nexus, right? I mean, isn't that's sort of the heart of the question. And we look at two cases to try to find out, to try to interpret what a substantial nexus is. One of those cases is a United States Supreme Court case. The other case is a state court case out of New York Tax Court. And so we'll start with the U.S. Supreme Court case. It's Quill v. North Dakota, the state of North Dakota. And this is a case from 1992, before the commercialization of the internet. And it deals with Quill, which is a multi-hundred-million-dollar mail order business. And in the early 90s, Quill was shipping catalogs to the state of North Dakota, and they had shipped a really extraordinary amount of catalogs, mail order catalogs, like I think 25 tons or something along those lines. And they had built up 3,000 customers in the state of North Dakota, and they were doing about $1 million a year in mail order sales from California residents. I'm sorry, not from California, from North Dakota residents. But Quill was a Delaware company with its principal place of business in California, and it also had an office in Illinois. But the important thing is that Quill didn't have an office in North Dakota, and Quill didn't have any employees in North Dakota. And Quill's only contact with the state of North Dakota was sending these advertisements into the state. And so Quill was upset that the state of North Dakota was trying to make it collect sales taxes from this $1 million in revenue that it was generating. The state of North Dakota wanted to tax Quill, or wanted to tax any company, not just Quill, that sent more than 3 advertisements per year into the state. And so, Quill with its 25 tons of catalogs was definitely more than 3 advertisements per year. And so they wanted to levy this burden on Quill, this tax burden. And this case eventually made it all the way up to the Supreme Court. It went through North Dakota's trial court, North Dakota Supreme Court, eventually came up all the way to the U.S. Supreme Court on this constitutional question of, when do we have a substantial nexus so that it's fair for North Dakota to tax Quill, to levy this tax on Quill. And the Supreme Court gave us some guidance. And in essence, what they said is this. In order to have a substantial nexus, a business must have more than an insignificant presence within the state. More than an insignificant presence. So this case actually got remanded back to the trial court, and the Supreme Court decided that there was not a significant enough presence. Quill didn't have a significant enough presence within the state of North Dakota in order to levy these taxes that the state was trying to do. And so the reason is because Quill didn't have any employees there, they didn't have any offices there. In other words, they didn't have any physical presence in the state. And so that has, in short, that's pretty much the rule. You've got to have a physical presence of some sort, right? And it has to be more than an insignificant physical presence. So then we've got another case that might provide a little more guidance, and this is a tax case out of the state of New York. And the tax case says, first of all, the tax case was Orvis via the New York Tax Appeals Court. And Orvis is a Vermont company, and it was selling about $1 million to $1.5 million of computer products to residents of the state of New York. And they were making these sales by mail order. So this company didn't have any offices in the state of New York or anything like that, but they were making these mail order sales. And the trick with this case was that after they would make the sales, the Vermont company, Orvis, would from time to time have to send technicians from its Vermont office into the state of New York to actually service these computers that they had provided. So under warranty, they would have to provide some technical support and that kind of stuff. And it was actually on site in the state of New York. And so the tax court that heard this case decided that, well, we understand that you didn't have any offices in New York, and you didn't have any permanent employees in New York, but by sending these temporary tech support workers into our state, you have established a presence that's not an insignificant presence with our state, and as such, we form the basis of a substantial nexus. And so these are the two cases that the state of New York is relying on for this affiliate tax law. And the state of New York has issued some some service bulletins, technical bulletins that lay out what what merchants need to do to make sure that they're not creating this substantial nexus with the state of New York. And that's what I think our panelists will talk about today, and I can talk to you about that, but I think that by understanding the constitutional underpinnings and by understanding a little bit about what's the state using to determine what a substantial nexus is, hopefully you've got what it is and what it isn't. Hopefully you're armed with some more information so you can sort of decide with yourself whether your relationship with the state of New York creates this substantial nexus. And the state of New York has given us some guidelines too. We'll talk about those. Thanks.
Thank you, Clarke. Next we have Chris, who's going to talk a bit more about what Performix had suggested, and I believe a little bit about California.
Sure. So I think the most useful thing for the audience that I can share is if you're here as a merchant, here are some things to think about, and if you're here as a publisher, here are some things to think about, without stealing too much of Melanie's and Kim's thunder with kind of course of action. The most important thing you need to do is gain information, and there's actually several different places I think you can find information out on the web right now. First thing I'll say is that all of the major networks, Performix, which Google Affiliate, Linkshare, Commission Junction, basically put out very nebulous, not that helpful type of information because we couldn't. So I wouldn't turn to any of us for real concrete advice on this one. So I'm glad I'm here telling you that. But we really couldn't come forth with a point of view. So as I said earlier, the most important point of view I think you could seek as a merchant is to, in this particular case, get advice from counsel. But I will say that the DMA, the Direct Marketing Association, which is an extremely large organization, has held several webinars and/or conference calls on this issue. There was a gentleman there who probably has spoken the most informatively about it, was a guy by the name of George Isaacson. So I would just go to the DMA's site or search in Google and look up George Isaacson, and you might be able to find information from that perspective. The other thing that is out there right now, if you haven't seen it already, the state of California in early July also looked at the New York law, and they deemed that under California law, they do not feel that this nexus obligation is being created via an affiliate who resides in the state of California if a consumer purchased product from that affiliate site. So California has currently interpreted New York law not in the way New York did, and is not viewing this as a nexus obligation for merchants. The other encouraging thing was at the end of July, the New York Senate came out and stated that they have approved, let me get this language right, the New York Senate has approved legislation that would repeal the statutory presumption, and it's going to continue to go forth in front of the Assembly. The only thing I would caveat on that is the New York state budget, I believe, is $26 billion, billion, in deficit, and this they felt and estimated would be roughly $70 million in tax revenues they could get. So the same article that came out, and they did allude to that. But I guess we can stand here today and say at least the Senate within the state of New York is reconsidering their views on the bill that was previously passed 2 months prior. From a publisher perspective, I think you need to, if you're a publisher in the state of New York, or if you're a publisher in any state and you're concerned that this might become law in your state, I think the most important thing for you to do is study the current law and the language around solicitation. And I know Melanie's going to talk to that. But to me, that is the most important thing. And then I think the other thing, if you're a publisher, is your willingness to certify back to the merchant that you will comply. If you want to still do business and the merchant asks for you for something in writing, give them your signature, comply with the law and give them your signature. So that would be the view of the network right now is, gather as much information as you can. This is one to go out and spend a little extra money if you're a merchant and get counsel on. And I think if you're a publisher who wants to continue to do business, be willing to work with merchants as best you can on this. The merchants are in a somewhat tough situation because of the ambiguity of the law and kind of the fluidity of things. So that's kind of my views on this issue. I'll turn it over to Melanie, I believe.
Actually, Kim and I are going to do kind of tag team this part, so we're sitting down. Basically, the solution that we arrived at is it's a very simple two-step process that merchants and affiliates together have to take. And if everybody probably has or has seen these two agreements, one was drafted up by our lawyer, and the other we kind of simplified it and put it into dear affiliate, dear merchant, this is what we need. Now, what merchants have to do is, there's two steps. The first step of the process to avoiding a nexus in New York is you have to meet a contractual condition. And what that means is merchants are going to have to insert a paragraph, and we have a paragraph, and it's written with the guidelines of the technical service bulletins. And what this states is that affiliates are going to abide by certain guidelines. The number one thing is that what we cannot do is we cannot solicit on behalf of a merchant. So say for Kim, for 4 checks, I can't go out and run around the streets of New York saying, buy 4 checks, come to my website and buy 4 checks. I can't do that. I can't do direct PPC to her. I can't say, Kim, 4 checks has coupons, come to my site. I can't do that. I can't mention 4 checks at all. What I have to do is refer people to my website. And this is what that little agreement that you have to put in your terms states, is that we're going to adhere to these guidelines. Plain and simple, it's all detailed on these 2 documents, what you have to include in there. That's step 1. Step 2 is going to happen by May 31st of next year, 2009. That's the first time that document is going to be due. And it's a certification an affiliate has to sign stating that they adhere to the guidelines. It's a sworn statement. It could be an electronic signature or it can be an actual on a piece of paper, mail it into the merchant, whatever the merchant wants. Now, a couple of people are going to have to do a little bit extra. An affiliate's going to have to give up some of their information because a merchant's going to have to know that you're a New York affiliate. On that signed contract and that signed agreement that you're submitting next May, is going to be your name and your address. They have to have that. New York State has to have that if they go to Kim and start digging through her records. So we're going to have to give up a little bit of our privacy. A merchant is going to have to go through these two little easy steps. Not that difficult. Make it a pop-up when an affiliate applies to your program. Make it a pop-up. Agree to this extra terms and conditions. Fine. Come next year, make another pop-up come up. You have to submit this signed form. End of story. It's very, very easy, and it's easy to implement. And I think Kim can talk about not how easy it was to arrive at this whole decision, but how easy it was for her to kind of incorporate into her program.
It's just a matter of, as Melly said, that little paragraph that states what affiliates in New York can and can't do. It's just a matter of changing that, adding it to your current terms and conditions, and putting some type of a PDF online with your terms and conditions as well with that affidavit so that affiliates can easily find it. And then from a program manager standpoint, you have to follow up with those affiliates and make sure that you have received them in plenty of time to comply with that date. So it's not brain surgery. It's very easy. It's just an update to the terms and conditions. How often do we as affiliate program managers do that anyway? Or how often should we be? It's so simple. So simple. I'm just thankful we can even do it. But the affidavit collection should be very easy as well. You should be able to tell from the network perspective who your New York affiliates are. I run on ShareSale and Kalimbo. ShareSale can reach out to my New York affiliates on my behalf, and Kalimbo, we kind of use it as an in-house solution, so I have everyone's names and addresses there, and I can do what I need to do on that aspect.
We're we're continuing our efforts to work on the repeal of the law, but the repeal of the law is more of a long-term process, and right now, as was mentioned, the vote to repeal, it passed through the Senate. And it was passed through the Assembly. The Assembly stuck it in the Ways and Means Committee, and it's going to sit there. It doesn't have a sponsor. So what we're trying to do now is to get a sponsor for that part within the Ways and Means Committee, get the Ways and Means Committee to refer it back to Assembly so the Assembly can vote on it. And then from there, it'll have to go up to the governor, and then that'll be our next one that we work on is the governor of New York to get him to approve it. But I don't know about the likelihood of that. But we're still working on it. It's not a done deal, but what we came up with was a solution so that New York affiliates now can survive, because in all honesty, 6 months from now is too late for most of us. We're not going to survive that long. We're having trouble surviving now, and it's only been 2 months long.
Okay, so we have a couple options. What we wanted to do was first open up any questions that you all might have for any of the panel members. We have a microphone right here in the front. You're welcome to step up there, or I believe it's wireless, so I could walk around with it.
Canada-based merchants, does the law apply to?
It was indicated to us that it was.
I'm sorry, I didn't hear the question.
Canada-based merchants, does the law apply to? Do we still have to go through the same steps for New York-based affiliates?
I think so.
Yeah, Mark Klein deals with, he's from the Hodge & Ross, and he deals with some Canadian merchants as well, because one of the managers that was at our meeting in Albany, she had posed the question to me, and I had asked him about it, and he said, yes, it applies to Canadian as well.
That's really out of state.
Yeah. I'd say
This is kind of a legal question, but not really, so I know that you can't really give me an answer. What if I'm not an affiliate, I'm actually an employee now of a Canadian-based company, but I have a New York address because of the whole tax issue there too. So I'm an employee, but I'm not an affiliate. My website is signed up as an affiliate. That's kind of confusing, and the company that I work for is trying to translate this. You know, if we moved AmazingMoms.com business address to Toronto, and I'm just an employee, is that my body sitting in the Catskills of New York typing on a computer, is that a significant presence? That was one question. The other thing is, I had heard from an attorney that solicitation by banner advertisement or anything on your website, they still consider that to be solicitation. So is that just a matter of degree? Some attorneys are a little bit more neurotic than others? No,
Yeah,
that's-
the second question is pretty easy. And the second question is that mere advertising does not create a presumption of this nexus, this substantial nexus. So mere advertising doesn't create a presumption of a substantial nexus. Now, if you combine that mere advertising with an affiliate model, right? So that you're basically taking a piece of the sale, a piece of the action, so to speak. You're sharing revenue, right? That does create a rebuttable presumption of a nexus. And what my co-panelists are talking about with the solution, basically by certifying, by first of all having in your affiliate agreement that that you won't encourage or endorse or permit your affiliates to solicit in-state, and by then having a certification from your affiliates that they haven't solicited in-state within the past year. By doing those two things, you rebut that presumption. So the first question, though, is more difficult.
It is difficult, maybe you should get your card.
Yeah, but that should be a
Because it is
nexus,
confusing,
right?
I'm officially an employee, and so it's still, and so I did lose some of my affiliates, or my merchants as well. Most of them, my sales were high enough for this, never mind, and so that's part of it too, is the merchants, I don't know if you guys as merchants looked, if the sales were high enough, they didn't drop some of the New York people, and then there were the ones that ran to the hills with their trip. So I think it's the ambiguity, and it's great that you guys are clarifying things a little bit, because I think the merchants were terrified. I actually read the law and thought I owed them, as an affiliate, I was like, wait a minute. So it is confusing, of course, attorneys get sued. Yeah, thank you, and you're
Clarke.
And you
Clarke
can
Walton.
work in other states.
Well, this is really at heart a constitutional issue in my mind. And so I can interpret the federal constitution, right?
All right, thank you.
If I could speak to that as well, something that Mark Klein said from Hodgson and Russ at our meeting in Albany that really resonated with me is that you can't say buy cheap checks from styleschecks@mikesite.com, but you can say buy cheap checks at mikesite.com. And on Mike's site, he can have my banner, my landing page, my product.
It's a merchant.
It's the soliciting versus the advertising.
We can never mention a merchant in our advertising out in any means. We can't even advertise that we have a coupon available for a particular merchant. And that's the thing.
External advertising. You can do anything you want to
Yeah.
on your website.
Yes.
External advertising, your name only, no merchant.
One thing I forgot to mention is if there's a member site or a loyalty site or a site on a group of a nonprofit organization that deals with members, they're going to have a little disclaimer or a little notice on their website that reminds their members that they cannot do certain things and they have to adhere to the guidelines. That's a third step, but that's only for member sites and loyalty sites. And again, we have a sample here, so you can make it easy.
Hey, I work for the Internet Marketing Center. We've got about 250,000 affiliates. I'm just curious to know, would this affect them if they were going to be email marketing campaigns doing product reviews or reviewing a company rather than promoting, directly promoting a company? Would that affect them through email marketing campaigns?
Is there a revenue share relationship?
Yes.
Then yes.
They get a
To the extent that's directed toward residents of New York.
Okay, now when you say revenue share, is there a cap to it? Like, does it only affect people that make $10,000 a month, or is it anyone that's from New York making commission?
This is one of the ambiguous parts of the statute.
Okay.
It's not certain, it's not clear whether it's $10,000 a month in aggregate among all of your affiliates within the state of New York, or if it's $10,000 a month like per affiliate. So you might have some affiliates that are doing less than $10,000 a month, and even if they were soliciting, then you may not have this obligation to pay the taxes.
Okay.
But you may have certain affiliates that are doing more than $10,000 a month.
Yeah.
On the other hand, New York State's probably going to argue that if you have in total all of your affiliates combined, if they're doing more than $10,000 a month, then you have to comply with this. And I would say that that's the conservative approach.
Now, I know there are some companies that actually transfer commissions and don't pay out $10,000 a month directly every month.
And by the way, it's not per month; it's per year.
Okay, so it's 10,000 per year.
Right.
So if you have a basic affiliate that's not making 10,000 a year, let's say they're making $9,950 a year, would that affect them as well?
It depends on whether it's one of those, whether you have other affiliates that would push that $10,000 thing over the aggregate $10,000 amount, or if it's just, if you only have one affiliate in New York, right, and that one affiliate does less than $10,000 a year, then you probably don't need to comply.
No, we have 250,000.
We'll see there.
Okay, thank you.
So another interesting thing that ShareSale has as a tool is there's a link you could click on. It will actually show you the past 4 quarters and the earnings from New York affiliates. So that's just one other thing that a network has further done to help us.
Do you have time for one more?
Of course.
But we did not get rid of our New York affiliates. We have them in our program, and we are charging sales tax to New York residents in addition to our own state. Do you suggest that I facilitate this arrangement even though we don't have to necessarily? Like, do you think it's just something we should have? Like, should merchants be doing this just to, does that make sense, kind of? Like, is this something we should have even though don't have to?
Wouldn't you want to be wouldn't you want to be prepared so you
Right.
don't have to go through this? If you
Right,
once you meet the
exactly.
nexus, you've met the nexus and it's due. So you might as well institute it now, and you don't even have to worry or think about it.
Yeah, exactly.
Do it now.
Because
Why wait?
I can feel for Kim because it's not always the affiliate manager's decision. I mean, you know, sweat the meeting prior with these people for years, and it's not always your decision. So I think, I guess, in answering my own question, I can ask this on purpose to let advertisers know that they should get going on this ASAP, and so we work getting a solution. Right.
There's some really good guidance for the solution, in addition to what's published here in these papers, which is good. Also, if you want to get it from the source, read the technical service bulletins that the New York State Tax Office put out. One was published in May, another one was published on June 30th, and you need to read them together, both of them, to really get the best, I think, answers for how New York interprets this stuff.
Does anybody else have a question?
One of the questions was about the nexus in Canada, the employee being in New York. The way the internet lawyer explained it, and again, some companies recommended, well, you could set up something in, let's say, Pennsylvania, but if you still have their residence in New York, it's still a nexus. no matter
Yeah,
what.
you're actually, right. So we don't even, if you have an employee in New York, if you have a business, I don't care where your business is, and you have an employee in New York, you have met the nexus test, period. If that is not an employee, but it's an independent contractor with an affiliate relationship, then there's a presumption of a nexus that can be rebutted by taking these 2 other steps.
So there's another thing that was floating around the web where some merchants were encouraging affiliates to incorporate in other states. This is not a solution, and it's something you probably do not want to recommend to your affiliates, and you do not want to do. Just wanted to let you all know that that will not work, and it's pretty much fraud. So, and plus, if all of a sudden the law would pass in the next state where you just incorporate it in, then what are you going to do? Incorporate it in another state. So that is not a solution. Do we have any other questions? Okay, so there's some other topics that we wanted to talk about. So suppose you're a merchant like 4Checks that had to remove affiliates, but you can now accept them back in. There could be some animosity towards the merchant for removing affiliates. And although there's no answer and every affiliate's going to be different on how you bring them back into your program, and just what are some of the things you, Melanie, would like to see from the merchant? And Kim, how do you feel you're going to approach bringing affiliates back from New York?
I'll go first. There really isn't any approach that I have other than honesty is the best policy. It isn't, as she stated, the affiliate manager's decision all the time. It was our legal and our CFO and just making the best business decision for our company at the time. And business decision to me is a little heartless, because this isn't just someone's business. This is how they feed their children. This is how they pay their mortgage. This is a big deal. And it's not going to be something that you can just say, sorry, and they're just going to roll over and come back again. It might not happen. I don't have any expectations that New York affiliates will be lined up ready to work with me again. I can hope for it, but I certainly don't hold that expectation. I don't think any merchant should. I don't think an increase in commissions could hurt. I don't think maybe putting some type of an incentive in place, specifically dealing with their situation and the fact that they probably haven't sent you any sales in the last 2 months. Maybe some type of incentive program where if you increase your sales by X amount, you can get this additional amount, because you have to remember that probably for 2 months, as Millie alluded to, that they've lost 30 to 90% of their income, and it's not replaceable. So anything that you can do to make up for that on the merchant side, I would strongly suggest you take a look at that.
I think when you want to think about how affiliates are going to react to getting back into programs, you have to separate merchants into 2 categories. You have the category, the one group, where they let us know either ahead of time, even if it was the day before, that they were going to terminate us. You have that group. Then you have that other group that waited until June 15th, June 16th to saying, we're deactivating you, retroactive to May 31st. That group, in my opinion, doesn't have a prayer of getting any New York affiliate back, and I think they are really in danger when that becomes more publicly known that they did these tactics. They're in danger of losing other affiliates, because that's a merchant that does not value at all an affiliate. Now, going back to the group where they let us know either 2 weeks before, 3 weeks before, or even 24 hours before, even though that kind of devastated many of us, it's a business. We understand now that merchants had to make this business decision, pure and simple. So now my approach, it's a business decision. Do I think I can make money from this merchant again? Yes. Okay, will I be as loyal, as trusting? Honestly, probably not, because you know what? It happened to us once, and it can happen again. And it happened to a New York affiliate, and it can happen to any affiliate from anywhere. And that's, you have to always not keep your guard up, but keep that in the back of your mind. It's going to happen. But bottom line is I'm going to make a business decision. I'm going to promote 4 checks. Why? Because I can make money at it, and it's a good program and a phenomenal manager. No, but that's what we're going to look at. We're not going to, I'd say 99% of us are going to be motivated by the monetary aspect. Will we make money?
And from an affiliate manager standpoint, I'm just hopeful that maybe my links haven't already been swapped for the competition's who is complying. It may just be too much of a hassle to put my stuff back up there again, and I just can't have that expectation.
It's a lot of work to put links up. I'm sure you know that, but it was a lot of work tearing them down. We had sites that took 5, 6, 7 years to build, and we had to pull thousands of links from there. Now we have to go back and put them in. You know what? It's going to be a little bit of a process, so don't expect me to get it done next week or the week after.
1 second. We have Chuck.
Sorry.
Are there any other states that are in the process of putting together a law similar to this? Is there anything out there that...
Well, Washington's coming sort of close, the state of Washington. They haven't done anything like this. What they've done is change the way, so for sales tax purposes inside of a state, the state of Washington used to handle sales tax purposes like this. Wherever the product was actually sold, that is what determines who collects the sales tax and what the sales tax rate is. Washington just changed to where the product is actually delivered determines the sales tax rate. So this is right now all inside the state of Washington, but you know, Washington and other states are paying really close attention to what New York is doing here because they all want a piece of the pie. And there's also there's some federal legislation too, right? That so we, you know, this is in a lot of ways sort of a federal issue, right? Because we're dealing with interstate commerce, and so there are. There is a bill. I don't know what the progress of the bill is. I can only remember the name of the bill, but I've read it, and it deals with you know, collection of taxes for internet transactions among the states. And to my knowledge, I think there are maybe 15 or 20 states that are taking steps to support that bill. one of the steps that they take in order to support it is to do what Washington just did, which is change the way they determine the rate at which sales taxes are collected, whether it's where the item is sold or whether the item is actually delivered. So that's like the first step that a state takes in order to get on board with this national law, this national
Clarke, I
bill.
think that's called the streamlined sales tax
Yeah,
agreement or
something like
simplified
that,
sales
right.
tax agreement, one of the two. And that is a big
Universal,
deal.
I think it's universal streamlined sales tax
Sure.
group or something like that.
What about big population states like California and Texas?
So California interpreted the New York judgment on nexus exactly the opposite. They interpreted it didn't create nexus in the state of California. That's their current interpretation. It could change over time, depending probably on what, ultimately how things play out in New York. And the only other state I've heard who's in doing something in this, I'm sure others are considering, is the state of Washington.
Right.
Those are the three, New York.
And so states can differ on how they interpret what is a substantial nexus. To have a substantial nexus, we need more than a slight presence, right? So states can differ on what's more than a slight presence.
One last question. I noticed that one of my top affiliates changed his address. I don't know if he changed his corporation.
This is
It follows the same-
this
same
is actually this is a really good question because for these two requirements that seem so easy to satisfy, right? Which are one, put this statement in your terms of service that you're not going to accept affiliates that solicit in the state of New York, right? And second, get this certification from your affiliates. Well, to accept that certification, one of the things that the merchant has to do is that it has to accept it with good faith knowledge that the affiliate hasn't actually solicited inside the state. So if the affiliate lies on the certification and you either know that the affiliate is lying or have reason to believe that the affiliate is lying, then you're not exempt. So that's the good faith portion.
Thank you. I just wanted to ask because I think it's important, if you remember when we were talking to Mark about how even, merchants can't benefit from having terminated their New York affiliates and then permitting those links to remain active so that if the affiliate, for whatever reason, hasn't gotten around to removing them yet, the merchant cannot benefit from those sales without establishing nexus or being at risk for establishing nexus. And I was just wondering if you could go over that in a more articulate way, because I think it's really important for indies, especially, to know that this isn't like a free-for-all that they can take advantage of. I know most of the networks will shut links down once affiliates have been terminated from the program, but it may be the case with independents where that's not happened. And those independents are putting themselves at risk for establishing nexus by not clearing that situation up. I guess I answered my own
Yes,
question.
you did a great job. Now, there's quite a few, there's not quite a few, but there are some merchants who forgot to deactivate the links. And but we're not getting paid for the sales, but those links are good, they go through. And that merchant now has a nexus.
I have two questions. One is, can anybody give us some examples of acceptable ways of promoting an offer or a company under these laws if you're a New York affiliate? For instance, our website we consider ourselves publishers and we have advertising space and sometimes space in our newsletters. We sell CPM advertising, sometimes we fill in, backfill with the affiliate offers. But when can we use, how can we promote an affiliate offer without creating nexus for the merchant? That's the first question. The second question has to do with this agreement. Now, if an affiliate signs a certification and then somewhere down the road, New York decides something they are doing that they thought was within the bounds and did not create nexus for the merchant, suddenly now creates nexus for the merchant, what legal ramifications does that have for the affiliate?
Okay, so the first question, it's sort of, I think the easiest way to answer the first question is this. To the extent that your affiliates engage in any activity that is promoting an affiliate offer directly to the residents of New York, you have a potential problem. So so there are some easy ways. If you're handing out flyers on the street, right, then you're directing your marketing efforts toward New York residents. And then there are some tougher questions, like what if you're doing a pay-per-click campaign and you're geo-targeting the state of New York, right, or certain zip codes or something like that? Well, that's arguably going to create a nexus, right? What if you're doing email marketing, and email marketing is one of the explicit ways that the state of New York says that a nexus can be created. And if that email marketing is to residents of New York, and you know that it's to residents of New York instead of just to the nation at large, then I would say that you've got a potential problem. To the extent that the promotions that you're engaging in are on the web and directed to the nation at large, then I don't think that you probably have a very strong nexus problem.
Even though that we know that a large percentage of our audience is from New York. You know, we don't
As long as you're not directly soliciting on behalf of a merchant.
Well, how
You can write a newsletter, you can write whatever article you want on there, you can write whatever product from that newsletter. You don't want to direct your newsletter reader to the merchant site. You have to bring that person, you can't mention that merchant by name. That's the #1 rule. Bring them to your own website and then send them off wherever you got to send them to click to buy or whatever, whatever your tacit is.
So you can run a promotion on the website, you simply can't run it in the newsletter, even though you're still advertising.
If the newsletter goes to New York residents and you know that it's going, it's like if you know that the newsletter is predominantly going to New York residents, then you probably shouldn't have any you probably shouldn't have any affiliate links in there if you want to minimize the likelihood that you're going to have a problem. And I mean, here's the bottom line on this stuff, guys. It's basically brand new, right? So we don't have a lot of information to interpret it. And so we make decisions depending on what our tolerance for risk is, right? And if 90% of your email marketing is to residents of New York, and you have a low tolerance for risk, then you wouldn't want to put any affiliate links in there.
Okay, but by the same token, now say you take the same 20% off coupon that the merchant is providing and you just run it on the website. You can't do that either?
Well, I would say that if you just, no, I would say that if you just put it on the website, you would be, I would say on the website, if you just put it on the website, you'd have a much greater argument. And that would be even if, even if a lot of your traffic to your website was from residents of New York, I'd say that you'd still have a much better argument there than if you knew that 90% of your email marketing was going to New York residents. Does that make sense?
It's just not confusing to me. It's annoying to me as a publisher because basically, to me, all of that space is advertising space. And whether I sell it as CPM advertising, whether I sell it as sponsorship, or whether I sell it as CPA. CPA advertising has been in magazines for years too. I mean, why should New York regulate how I make money for my advertising inventory? Anyway, but the second part of the question too was important because suppose an affiliate only has a banner on their website, and next year New York says, oh, that really created Nexus too. Now, we've signed the certification saying we're not doing anything we shouldn't. Can that come back to haunt the affiliate?
Well, the certification gets signed every year. So if the law changes or the interpretation of the law changes, then, I mean, if they sign it when the law is okay and the interpretation of the law is okay, then they're probably not going to be hurt down the road. If the interpretation of the law changes, right, then they would need to consider whether it's right for them to sign it or not the next year, in subsequent years.
Well, it's 4 o'clock now, so we're out of time. I'd like to thank Clarke from Walton Weblaw, Melanie from NewYorkAffiliateVoice.com, Kim from 4Checks, and Chris from the Google Affiliate Network, and everyone for coming. Strongly encourage you to read Melanie's blog and to visit sites like ABestWeb to read the discussions that are going on. you.